Buying a new construction condo in NYC? 5 legal risks to avoid. Buying a new construction condominium in New York City can feel exciting, but it is also one of the most legally complex real estate transactions buyers face. Unlike resale purchases, new development deals are governed by sponsor-drafted contracts, lengthy construction timelines, and offering plans that often favor the developer. Even sophisticated purchasers can overlook provisions that affect long-term costs, ownership rights, and resale value if these documents are not carefully reviewed. New construction condos present a distinct legal landscape because the sponsor controls the terms, disclosures, and timing of the transaction. One major risk involves the shifting of closing costs and transfer tax liability. Although New York law places transfer taxes on the seller, many offering plans require buyers to pay those taxes on the sponsor's behalf. When buyers pay the seller's tax obligation, that payment is treated as additional consideration, which increases the taxable amount and raises the total cash required at closing. These taxes generally cannot be financed, making the financial impact immediate and significant. Another overlooked issue involves additional fees imposed on buyers. Sponsors often require buyers to pay the sponsor's attorney fee, contribute to the building's working capital fund, and cover other startup expenses that would normally be borne by the developer. While some of these charges may be negotiable depending on timing and market conditions, they are frequently accepted without challenge, increasing the true purchase price of the unit. Physical discrepancies within the apartment itself also present legal risk. Square footage in New York City is calculated according to measurements defined in the offering plan, not by usable living space. Advertised square footage may include wall thickness and portions of common elements, resulting in a significant loss factor. Courts generally uphold these practices as long as they are disclosed, leaving buyers with limited remedies after closing. Warranty protection is also narrower than many buyers expect. The housing merchant implied warranty provides limited coverage over defined time periods and requires strict written notice. Failure to follow those notice requirements can eliminate warranty rights entirely. Timing uncertainty is another critical concern. New construction contracts usually do not include firm closing dates. Instead, they rely on an anticipated first closing date that is not binding and an outside date that controls when a buyer may cancel if construction is delayed. Sponsors often extend outside dates far into the future and expand force majeure clauses to include supply chain issues, labor shortages, and government restrictions. These provisions can leave a buyer's deposit tied up for years with little ability to exit the contract. Governance and financing risks also affect long-term value. During the sponsor control period, the sponsor typically controls the board and budget decisions. Budgets disclosed in the offering plan may understate future common charges, and conflicts of interest can delay repairs to common areas. Buildings can also become non-warrantable if sponsors retain too many units, rent unsold inventory, or exceed lender thresholds for commercial space. When this happens, buyers may be unable to obtain financing, and resale values can decline sharply. Tax exposure presents another layer of complexity. Many buyers assume new condos automatically qualify for tax abatements, but that is not guaranteed. The expiration of the 421A program and the restrictive requirements of its replacement create uncertainty around future property taxes. In addition, Local Law 97 imposes carbon emission limits on large buildings, with penalties passed on to owners through increased common charges or assessments if a building exceeds those limits. Because of these risks, working with a lawyer early in the process can help buyers understand the offering plan, identify red flags, and negotiate protections before signing. A lawyer familiar with new development transactions can also explain how timelines, warranties, and tax exposure affect long-term ownership. An attorney can evaluate whether closing costs are being shifted improperly and whether exit rights are realistically enforceable. An attorney can also help buyers assess governance provisions that influence financing and resale. Choosing the right law firm matters, as experience with Manhattan condominium transactions allows the law firm to anticipate issues that are not obvious from marketing materials alone. Buying a new construction condo offers modern design and new amenities, but those benefits come with hidden legal and financial risks. Taking the time to understand these issues before signing can prevent costly surprises and protect a buyer's investment. If you are considering a new development purchase or need clarity on a contract already in progress, Avenue Law Firm is available to provide guidance with care and attention. Avenue Law Firm can be reached at 212-729-4090 and is located at 505 Park Avenue Suite 202, New York, New York, 10022, United States, where buyers can discuss their concerns and move forward with greater confidence.